Parker. This is Kristen Ishihara with the Ishihara and Parker Law Firm here in Longview, Texas. And today we are discussing what happens when you basically fail to plan. In this case, when you do not get a will done or your spouse does not get a will done. Kristen, what happens? What's the big overriding thoughts?
Yeah, mostly we set that up so we could say that a failure to plan is a plan to fail.
That's right. That's right.
Yes.
We
Happy
thought of
Friday.
that. We
That's
thought of
right.
that.
That's ours entirely. But the actual answer to the question is if I don't take the opportunity to have a will in place, remember a validly done will has to be a correctly executed will valid under the laws of the state you're living in. We're talking about Texas. But if I fail to have a will in place, Texas writes it for me. Some people think that that means that the state comes in and takes your property, and they don't, but they say who gets your property based on some assumptions about who they think should get the property or other, valid reasons. But Texas will say, with no wiggle room.
And we're having difficulties.
Yep. Okay, I think it's coming back. But Texas will say, just period, this is who gets what. There is no wiggle room. There is no, but I've paid for this for years. I've handled this for years. I caregived for mom for years. She's been estranged for this child for years. There is no subjective, emotional, anything that matters. It just is what it is. Texas says what your will is. And that's what we want to talk about today.
And usually you don't find that answer out until a major life event is happening. Like, hey, suddenly I've been single for 15 years because my spouse passed away, and now I'm selling the house because I need that money to pay for medical bills or downsize or whatever, and suddenly I don't get all those proceeds. Right? Title company says, well, wait a minute now, we have some questions. And so sometimes this is a huge surprise to spouses or surviving spouses who had just no idea that they were going to be half as rich as they thought they were in some scenarios.
I think that's absolutely the most common scenario that this comes up. A second marriage, one spouse dies, the surviving spouse goes to sell the house, assumes that she owns it, and she doesn't.
Yep.
And that's 100% probably the most common way that we see this come up for people, where they are surprised that when their spouse didn't take the opportunity to put a will in place, that they don't own what they thought they owned.
And the other part of that is, let's say that surviving spouse lives for another 10, 15 years. They then pass away. The adult children of the surviving spouse who've been taking care of mom for the last 10 or 15 years go to sell the house and find out, like, what? Stepdad's son from 40 years ago who had no contact with suddenly is involved in this and actually has an ownership interest? Yes, lots of nasty surprises. So basically, things to understand. If you do not have a will or your spouse does not have a will, Texas writes one for you, and it divides your world up into different categories, right? The easiest ones, I think, are, is the deceased person, are they married? Are they single? We're going with the standpoint of married with children, right? If that person dies and they're married with children, what happens to their things? So they're separate personal property. Separate meaning property acquired before that marriage, or property inherited or gifted. And personal property usually means what? The smaller things, cash. What do you mean there?
Yeah, so personal property is going to be bank accounts, investment accounts, any sort of account with money in it, as well as personal tangible property, which would be clothing, furniture, cars, anything that you could move around that's not affixed to land, which would be part of your land plus improvements.
That's either from before the marriage or gifted or inherited. Those are all presumed to be your separate personal property. And the law says in that case, the surviving spouse would get 1/3, and the children of the decedent, all the children of the decedent, even y'all's kids or his kids or her kids from before, would split the rest equally.
Yeah.
Next category would be real property, separate real property. So this would be land, right? Land owned either before marriage or land that's gifted or inherited during the marriage. The law gets a little bit different here. The surviving spouse gets a 1/3 life estate, and the remainder interest goes to all of the decedent's children equally.
Depending on your marriage, though. So it depends on whether it's community property and you're married with kids just of the marriage. So it does make a difference what sort of character of your family on that. And also, I think land is a little confusing. So we are talking not just about land, farmland, other things. We're talking about your house. So real property, land, when we say that, we mean any actual real property that you own, which is likely to be your residence, as your main example.
Well, but anything before marriage or acquired during marriage as gift or inheritance would be presumed separate.
Yes.
Okay. And that's a problem for some people on certain issues. And then we have what the law would say would be community property. Community property is pretty easy to understand. It's anything that's acquired during marriage is presumed to be community property, right? Whether it's land, whether it's personal property, if it's acquired during marriage, it's presumed to be community property. And then the law is very clear. The spouse who's surviving always keeps their interest, right? But the half of the estate, the half of everything, I shouldn't say, the half of everything that belongs to the deceased person goes to their children if they have children from outside that marriage. So let me say that again. If all children of the marriage are, mother and father have all the same children, or all children of the marriage, you're in an okay spot most likely because everything would go to surviving spouse. But if the decedent had a child that is not your child, had their own separate child, then their part of the estate or their part of everything would go to all of the kids equally.
Right. So the times to look out for: children outside of marriage, separate property owned before marriage or inherited at any time. Could be during the marriage. If somebody were gifted or inherited the house that you're living in, that's an important time to remember. That is not your community property, even if it was gifted or inherited during your marriage.
Big problems that we see over and over are surviving spouse problems. Let's say it that way. Surviving spouse comes in, says, hey, I'm living on land that my husband either owned before or was given to him by his parents. And I say, well, that's a prime example of what's going to be considered separate property, and your rights are going to be much more narrow. Your ownership may just be a life estate. You may not own any of it if it's acquired before marriage. So there are real problems. Other issues I see. People come in and say, well, Chris, I think we fixed the problem. I've seen this a bunch of times. I own something beforehand. My wife and I get married, and I'm thinking I want to do right by our relationship, so I gift her one half of what I own, right? Sounds like the perfect solution. I own it 100%. We get married. I want to treat her as a partner, so I give her one half of what I own. Does that solution work?
I've probably assumed that when I gift it to her, when she dies, I'm going to get it back, and that's wrong. It's a gift that she received, so it's her separate property. So that separate property will go through the will that Texas sets for her unless she's taken the opportunity to do her own will, but then that will go to her kids.
Yep, I've seen that play out multiple times where people doing the right thing, couples doing the right thing, they're blended families. One partner already has a house. They want to join as one. They gift their 1/2 interest to their partner. Then their partner dies, and that 1/2 of the home they gave to their partner now passed to their deceased partner's children.
So the message, of course, is have a will, have that done correctly. But we also want to talk about, let's say that maybe just your parent, a single parent has died, and you're left trying to figure out now what to do. And you realize that your parent did not leave a will, but there are assets that your parent owned that need to be handled. So they had a bank account, or they had life insurance, or an investment account, or land, or car, or personal property. So if that has happened, what is the process for handling those assets? As we've just kind of gone through, Texas is going to tell you who they go to, right? That's set in stone. You can't change that. Doesn't matter what you think about it or if you're happy or unhappy about it. That just is going to happen the way Texas law says that it is. But you still have to have a process for setting up an estate. So we're going to talk real briefly just about what that process is. You would have to retain an attorney to set up that kind of administration and estate. But we want to go through kind of what that would look like.
Yeah, for me, I guess, when I talk to folks, I say, look, step one is to contact the financial institution and say, hey, am I by chance a beneficiary? Like maybe there's maybe we didn't do a will, but maybe the financial institution set it up so it would pass outside of the rules of probate or intestate succession, and there's someone named. If you're the person that's named, they'll say, great, we need to talk to you, we need more information. You may not be the person named, or there may be no one named, and sometimes you can't tell the difference, and you're forced to take the next step, which I think would be a determination of heirship. You got to start a legal proceeding. You're going to have to eventually file a petition with the court. You're going to have to go before the court. You're going to have to allege the facts. The statements are, hey, my loved one passed away. They were either single or married. They had X number of children. There is no will. And here's the proposed division of property, whatever it may be, 1/3, 1/3, 1/2, 1/2, and you lay it all out. Once you file your petition, the court gets involved, and they will appoint another attorney.
Right.
Hey.
So what's more expensive about the determination of heirship is You have to have an attorney that does the research essentially for you. So in that application, you're saying who you believe the heirs are, but then the court will appoint an attorney to investigate that, and they'll read the obituary, they'll do their own research. You have to provide 2 disinterested witnesses that will confirm the family history by signing an affidavit and attending the hearing and talking to that attorney ad litem. Usually that attorney ad litem maybe knows some other people in town that they may call and check up on. So they're trying to establish that we're not hiding any heirs or giving them bad information to try and get a bigger distribution. But they're going to report to the court what their findings are, and then everybody will have a hearing together. You also have to notify all the heirs. So if mom has died and mom had 3 kids, hopefully everybody gets along fine, and then this is much easier. But as part of that process, you have to notify each of the potential heirs, and they have the opportunity to come to court and tell the court, 1, they think they should be the administrator, not you, or 2, they think, you've misrepresented what the facts are. And then at that point, the determination of heirship is done. That's really set in stone once you know who the heirs are. But then determining who will be the administrator, which is similar to an executor, who will administer the affairs of the estate, is then what you're talking about. And you can be an independent administrator without court oversight only if the other heirs sign and give consent for you to do so. That is the easiest, cleanest, best option, because then from that point forward, you have letters of administration, you can sell assets, collect assets into the estate, and move about your business. But Chris, what happens if one sibling doesn't get along and they refuse to sign? What happens then?
Now you're looking at a potential dependent administration where every step of the process you will need court approval. Like, hey, I'd like to sell this property so the money could go into the estate account to be distributed according to percentages. Sure, you can do that. Just as soon as you file an application, get court permission, actually get a contract, get court approval to sell it. Trying to sell a house to a dependent administration takes multiple steps. You have to really work really well with the title company. You're looking at a lot of time, money, and hassle.
Right, and you've paid the attorney to do all of those extra things. That's coming out of the estate. That's taking away from her share, your share, everybody's share.
Yep.
It's a real hassle.
I would just say I was involved in a administration like this where there was an application, and there's only this heir or this heir, and once we did a little research, there was over 50 heirs that they forgot about.
Yeah.
These.
And a lot of times I would say that's not necessarily intentional. Sometimes when someone comes and tells you about the family, they just say, well, she had 3 kids. They mean living kids.
Right.
And if the attorney hasn't asked more questions to get, she had 2 deceased children.
And then those deceased children's children count.
Right. And so that becomes, much more complicated. So when somebody passes, it is all of their children that matter. Mm-hmm. And then if that deceased child had children, those kids are going to split that share. So they're going to have to sign to consent to you serving. They're going to get a share. If they're minors, that's extra complicated. If you haven't maintained contact with them, that's extra complicated. So you can go through the process of setting up a determination of heirship and an administration of an estate, and you may have to. That just may be what you have to do, especially if there are bank accounts or liquid assets and there are no beneficiaries listed on them. That's really going to be your only option to get those assets, so it's probably worth it. But I think the message is make sure that you have a will and that your parent has a will. Yes. Sometimes people delay putting that in place because they you'll work it out, or I don't want to offend your sister by listing you as executor. Yeah. This now is what you would have to deal with sister if that comes to play where there is no will. So what you need is a will and a named independent executor to make it as smooth and as easy as possible so that the person who is actually going to take on the burden of handling the estate has everything they need.
Yeah, a will never really helps. Your will never helps you, but it certainly helps the next folks or generation. If you're married and it's a blended family, you need to know if your spouse will do a will or not, so you actually know what you own. If you're an adult child and your parents are older, you need to make them have a will so it makes your job possible.
Right, and I would say especially if there's any conflict among the kids where you think one is going to be difficult or give you a hard time. I mean, that with death, with now money involved, with emotions involved, it is just crisis times 100. So you really need those things lined out if there is any sort of conflict in the kids.
I've seen people just say, this isn't worth it. This isn't worth it. They literally leave assets with clouded titles because, in other words, the fruits of the labor of mom and dad are squandered because no one planned, and now nobody can get along to sort out what should have been a fairly easy process.
Right. And that's an interesting answer as well. So let's say you didn't administer the estate and you just left it. Real property eventually will be foreclosed on by the taxing entity because no one's paying taxes. So that actually will eventually go to the taxing entities. Bank accounts and other things, if they aren't claimed after a period of time, can be up to 7 years, that will get sent to unclaimed property within the state. But then to claim it, you still would need all the heirs to do so. So it wouldn't really help you at that point on that particular one. But there is a process where if things are unclaimed, they do actually end up going to the state. So you have the opportunity to set up an estate, tell the court who the heirs are, and take those over and administer them. But if you don't, then I guess they do end up going to the state. So.
Yeah, I don't think the state of Texas minds this, this process being
Right.
complicated. Let
Right.
you figure out why, but I don't think they mind at all.
Anyway, message number 1, get your will done. Make sure your parents have their will done. That'll make it as easy as possible for you.
That's right.
Yep. Thanks for joining us. We'll see you next time.